Half a day. Thank you everyone for being here. The Committee on Health, Tourism, Historic Preservation, Land and Justice is now called to order. Today's Monday, May 6, 2019. The time is about 1:10 p.m. Notices for this roundtable were disseminated via email to all senators and main media broadcasting outlets on April 19 and 26, 2019, and again on May 3rd. The notice was also published in the Guam Daily Post on April 22 and April 26, 2019. So today's agenda is a discussion on sentencing laws, rehabilitation, and parole, and how we can better protect our community from repeat sex offenders in particular. Our goal is to determine if there is adequate assessment, treatment, or rehabilitation for repeat criminal sexual contact offenders, and if any such tools are currently being used or should be incorporated into sentencing and parole. In terms of the order, we will discuss issues regarding parole first, and then sentencing options and treatment of rehabilitation of repeat sex offenders. I'd like to acknowledge right now the presence of my colleagues, the Vice Speaker Talina Nelson, Senator Kelly Marsh Taitano, Senator Mary Camacho Torres, Senator Regine Bisco Lee, Senator Clint Rigel. Situs Masi for being here, Senators. I'd also like to very quickly, because you will also have a chance to speak, but just to very quickly introduce yourself. I'm passing the sign-in sheet. We're making copies, and I'll pass that out to the senators so they'll remember who's who. But if you could just very quickly state your name and who you are representing today.
All right. Hafaday, Michelle Hope Taitano. I'm chairwoman of the Guam Parole Board.
Hafaday, Tom Van Engen, Parole Board member.
Hafaday, Mark Perez, social worker at DOC.
Hafaday, my name is Ron Santos, Parole Officer, Department of Corrections.
Mike Yanata, Parole Officer, Corrections.
Fill in for me, and then I'll come back after.
Yes, we do have other representatives from the Attorney General's office. Thank you very much, attorneys and other staff members. And from the Public Defender's office, I see other representatives as well. And from the Court's Probation Division, Situs Masi. Thank you all very much. Yes? Oh. Oh, thank you very much. Parole board members, thank you very much. Lena Hammond and Steve Guerrero, thank you very much. Okay. I'm sorry about the tight conditions. And thank you, Senator Amanda Shelton, for joining us. All right, so I did send to some agencies some questions to gather some information prior to this hearing, or just to kind of give an assurance of what we were going to be covering today. So I want to thank all of you who submitted answers in advance just to help us gather that information, and for being here today to provide also additional information. I also want to begin this discussion by a brief discussion of the Paul Moffness case. Now I'm talking about the past. We're going to use that as an example because it's been in the news, so everybody's pretty familiar with this case. But I know that there's a future or a pending case, so we're not going to talk about that. We want to just talk about kind of the circumstances of his release in 2014 or 2018. So according to the news and from information we've obtained from the parole board, Moffness pled guilty in 1999, was sentenced to 27 years of imprisonment plus 5 years of parole. He served 18 of 27 years, which was 67% of his sentence, and he was granted parole in 2014 and released from parole in 2018 after 4 years of parole. He was sentenced pursuant to previous sentencing laws prior to the adoption of the laws that are currently in place, which have a mandatory minimum sentence and a possible maximum sentence of life imprisonment without parole, which were adopted in 1996. I use this as an example of other potential cases whose sentences may be ending soon and who may be eligible for release or parole in accordance with the law and their sentence at the time. As we use this example, I want to avoid putting anyone in a position that may impact his current case, so please feel free to refrain from any details when necessary. So beginning with parole, we have standards in our code right now, 9 GCA 80.76. I think that's been passed out to the senators and maybe everybody, which they're the standards governing release on parole. It lists all of the factors and information that the parole board must consider before ordering release. And we also have 80.78, which details the records that shall be made available to the board, the parole board, when they are considering release. So the parole board, according to 80.76, is authorized to consider release if it is of the opinion that, and I'm going to read these real quick because some of you have them, but just for the benefit of the public so they can follow along with what we're looking at. His release is compatible with public safety and security. There is substantial likelihood that he will abide by law and conform to the conditions of parole. His release at the time would not depreciate the seriousness of his crime nor promote disrespect for the law. His release would not have a substantially adverse effect on institutional discipline, and his continued correctional treatment, medical care, or vocational or other training in the institution will not substantially enhance his capacity to lead a law-abiding life when released at a later date. In making its determination, the board may consider the following factors: personality, age and maturity, stability, sense of responsibility, apparent development in personality which may promote or hinder conformity to law. The prisoner's parole plan. Prisoner's ability and readiness to assume obligations and undertake responsibilities. Prisoner's family status and whether he has relatives who display interest in him and other close associations in the community. Employment history, occupational skills and training, stability of past employment. Type of home environment in which he plans to live. Prisoner's past use of narcotics or harmful drugs, or past habitual and excessive use of alcohol. Prisoner's mental and physical makeup, including disability or handicap that may affect his conformity to law. Prior criminal record, including nature and circumstances, recentness and frequency of previous offense. Attitude toward law and authority. Conduct in the institution, including whether he has taken advantage of the opportunities for self-improvement afforded by the institutional program. Conduct and attitude during any previous experience of probation or parole. The records that are supposed to be made available to the board are a report prepared by the institutional parole staff relating to personality, social history, adjustment to authority, including any recommendations which the staff may make. Official reports of prior criminal record, including reports and records of earlier probation and parole experience. Any pre-sentence investigation report of the sentencing court. Recommendations regarding his parole made at the time of sentencing by the sentencing judge or the prosecutor. Reports of any physical and mental examinations of the prisoner. Relevant information submitted by the prisoner, the victim of his crime, or other persons. The prisoner's parole plan. The record of his conduct while imprisoned, such other relevant info concerning the prisoner as may be reasonably available. I believe I've also passed out a sample of a parole plan, which is, it's blank, and that's just a sample form that we received from the parole board. I guess it's called a Parole Services Investigation Report. Thank you. Okay, so if we can start with the Attorney General and the Parole Board. I've asked them to tell us very briefly some of the factors in the Mofness case. Excuse me, can I also acknowledge the presence of the Director, Therese from the Guam Behavioral Health and Wellness Center. Thank you for being here. Generally, we would like to know, how did parole back in 2014, conform to these statutes? Did it? And For example, was a parole plan prepared? Did it detail his desirability? Was there a mental health evaluation prepared? And if the AG's office would take that one?
Well, I'm not at liberty to discuss any particular case, even the one that you've raised. Those questions, I believe, would be more appropriate coming from the parole board. But I do know when matters come up for parole hearings, we provide our input on whether we agree or disagree with the release of an individual, and that's the extent I feel comfortable commenting on.
All right. Are you able to comment on your recommendation in that case back in 2014?
I do not remember I was not involved in that decision-making process, so I don't know what the design, and I did not have time to check.
All right, thank you. All right, so let me refer to the parole board. For these questions, would that be Michelle Titano, chairperson? Are you the chairperson of the parole board?
Okay, he said he was going to turn it on. Thank you. Yes, ma'am. All those, we did adhere to that, all those conditions.
Was there a mental health evaluation or other professional evaluation provided to the parole board before the hearing?
One was requested, ma'am, but we did not receive one.
Was there any other report of mental status that you're aware of?
Not that I'm aware of, ma'am.
Were you provided reports of the pre-sentence investigation from the sentencing court?
We have reports, so yes, most of that is included in our investigative reports. I would have to look specifically at the file to answer that specifically.
All right. Well, we know from the news that you also considered testimony from the victim.
Yes, ma'am, always. That's part of their victims'
All right.
rights.
Okay, I'd like to now talk in general and not specifically about that case regarding parole and the assessment that the parole boards are using. And if we could hear from the Department of Corrections director, and I know that the deputy director is also here. Thank you for being here. Our chief parole officer is here, and the parole board. We wanted to know whether psychological evaluations are available to the parole board for consideration of criminal sexual conduct offenders in general. What other types of assessment or evaluation are prepared for the board, and are these effective in your opinion or accurate in determining the rehabilitation of sexual offenders or the likelihood of repeat offense?
Like the parole chairwoman Titano said, upon request, they can request for a psychological evaluation, and if it's available, it is given to the parole officer. Now, whether it is enough to determine whether the person will reoffend, I would say that's up to the psychologist doing it.
Is it your understanding that is it a psychological evaluation?
Yes.
Is always performed, or are there exceptions?
For the parole hearing, it's in my experience, it is not always performed on the client based upon the workload of the psychologist.
All right. Are there any other reports that you're aware of that may be available to them in the absence of a psychological evaluation?
In the past, no.
What types, what does, in addition to the parole report Is there any other reports that the parole, that you are in charge of giving to the parole board for their consideration?
When the parole officer does their investigation, they have full access to our inmate files. And so the parole officer will basically go in, get whatever copies are needed for the parole board to make their decision. Generally, they would be looking for the psychological evaluation, which is not held in my office. It would be held in the psychologist's.
All right, and the sentencing reports or the pre-sentence investigation reports, who gathers all that list of other information that's supposed to be made available? Is that the parole officers?
Yes. Okay.
And ma'am, what did you like to know? What other, you wanted, your investigation report, as we need to inform them about their behavior and programs they have taken. And if there's any disciplinary reports, we will submit that.
Okay, well, I'm asking because the blank parole investigation report, it asks for a, I think a psychological evaluation. It has that listed there, but it really doesn't have anything else listed. So I'm just wondering who's in charge of like the checklist of checking if there are any other of those reports, like pre-sentencing reports available from the sentencing court and the other items on the list.
If I may, so a PSI that's performed by the court will not be shared with the parole office. So they perform their own report. They
Right.
start over and they perform their own report. So the PSI that's done at the court by the probation officer is strictly for the parties at the court, and we usually don't get it. So our parole officers are the one that start all over and do the actual, it's called a parole investigative report.
Okay, so, but the statute lists that the parole board may have available to it any pre-sentence investigation report of the sentencing court, recommendations made at the time of sentencing by the sentencing judge or prosecutor. So is the Department of Corrections or the parole officers, are they able to get those and put those together as part of the packet that's going to be delivered to the parole board?
We don't provide the PSI. We're only there to review reports and extract whatever we need, but
All right.
we can't get a copy.
You cannot?
Cannot.
Is that correct?
My understanding is that there's a separate provision in the law that restricts the duplication of pre-sentence investigation reports once they have been submitted to the sentencing judge and to the attorneys involved in the case. In fact, our procedure is once a defendant has been sentenced, the pre-sentence investigation reports that are provided to counsels at the time of the sentencing are returned, the originals are returned back to the court for safekeeping.
All right, may I ask the parole board, have you ever seen these types of reports that are listed in this statute? A pre-sentence investigation report of the sentencing court or recommendations at the time of sentencing by the judge or the prosecutor?
Not specifically, ma'am.
All right. Okay, thank you. What training, is there any training that you're aware of that's given to the parole board members and parole officers, specifically in regards to sexual offenders?
There aren't any at the moment, ma'am, not specifically for sex offenses. We worked with the judicial a couple years ago. We were trying to get some, maybe a grant through the judiciary, and so we were looking into those areas, but I guess that didn't go through.
May I add briefly that I don't know if all the board members have, but I attended orientation for parole board members through the National Institute of Corrections. Got to fly to Denver for that training for a week or so. It's not specific to criminal sexual conduct.
All right. What about the parole officers? Do you receive special training regarding sexual offenses?
No, ma'am.
Right now, we have 2 that are attending through the court reentry program. They're the ones who were able to get the training, and that's caseworker Paris and 1 parole officer, Tanatongo Lisa. So right
Training
now-
for what? What is that training for?
Mark, can you explain?
In 2017, if I remember correctly, myself and parole officer Lisa Castro attended a sex offender program here on island. It's an evidence-based treatment program for sex offenders.
All right. Does that program been incorporated into the Department of Corrections?
Yes, we are actually on our second group.
So just recently? How
Yes.
recent is that, may I ask? How recent?
Recent, if I remember, we got trained in 2017, and we started our first group, and then the second group started last year. It is a 51 session program, so we can either take it 1 week at a time for 1 year, twice a week for 6 months. So it's a lengthy program.
What is the goal of that program?
The goal is to teach skills and to change their thinking process. That if they have a goal of never returning back to DOC, or if they have a positive goal, then they would have these skills to remind them what to do, how to get out of problematic situations. But ultimately, it's up to them to decide what do they want more.
So is there a specific component of the Department of Corrections that implements that program in particular? Or how does, yeah.
Yes, so we have our casework office, which is Mark Perez is a part of. So they do all the treatment and stuff. So they've been trained. The judiciary has been very kind and allowed some of our people to be trained. So the training that Mark is talking about is the CBI, sexual offender. It's cognitive behavior intervention that he's been trained on, as well as Lisa Tainatongo. So it's fairly new and stuff, and it's something that they're incorporating into our treatment programs that we have currently.
Are all criminal sexual offenders eligible for that program? Or how do you prioritize?
Yes, this sex offender program is strictly for the sex offenders. What we've been doing since we rolled it out in late 2017, we've been prioritizing those who are getting released soon. We can only take a maximum of 10 to 15, but unfortunately, they've been dropping out of the class, and so we've been graduating about five on each group.
All right. Okay, thank you. Generally, for the Department of Corrections, or do you keep statistics, or maybe the parole board does, but I had asked, how often has parole been granted to sex offenders over the objections of the victim or the victim's family?
So, ma'am, I'd just like to say that the victims do have rights, and they are contacted when folks come up. We do listen to the victims. Kind of depends on, it's a case by case, depending on how the offender has behaved inside programs taken.
Do you have any statistics, this Department of Corrections? Yes, Mr. Kanata.
27 cases granted parole since 2014. Of that, 9 cases that were granted were victims opposed to parole release.
9 out of 27, the victims
Yes.
opposed, but parole was granted.
Yes.
Thank you. How often have criminal sexual offenders been paroled prior to serving their full terms? I had asked how often criminal offenders had been paroled prior to serving 85% of their sentence, because the current law says if they've served 80, that's current law. If they serve 85%, then they're eligible for parole. But prior to that 1996 law, it just said they had to serve another percentage, 67%. Yes.
66.6.
Yes, 66.7. So Are there any that deviate from these requirements, I guess, is the question. Have any been released on parole prior to meeting these minimum 67% or
No.
85%? Thank you. Wait, press the button. Yeah.
Granted pardon for deportation.
Okay.
Those will be the ones that were met.
All right.
That, yeah.
And then again, just for the AG to make it very clear, so your role in the parole hearings in general.
We review the inmates based on the agenda, and then we review their file, and then we make a recommendation whether we agree or either agree, disagree, or defer to the board's decision.
Are you there when the board is making their determination?
No. We're there, give our input, and then we leave.
All right, so you don't hear the other input either from victims or anyone else?
There have been times I have been there when victims have come in, and I've been given permission to come in and sit with them, but usually I make my recommendations and I leave.
All right. Do you have a policy as to how do you determine whether to recommend parole or not?
I can't say we have a firm policy. We do look at it on a case-by-case basis. And depending on the severity of the crime and what the original charges were, that's what we look at.
Do you look at any treatment program that they've undertaken since that crime?
I don't have access to that. I just get the 1 or 2 page agenda to work off of.
So based on the crime?
That's correct.
All right. Okay, I'd like to also ask the directors of the Department of Corrections and Guam Behavioral Health and Wellness Center to talk about the types of rehab. So we've heard about the ones that are available, and I had asked over the last 20 years for sexual offenders on Guam while they're in prison or after release from prison. So in particular for sexual offenders.
So I can speak for DOC over the past 20 years, no, there was none.
Okay, until this recent CBI?
Yes, ma'am.
Thank you. Ms. Ariola.
Thank you, Senator. Currently, at the Guam Behavioral Health and Wellness Center, we do not have a sex offender treatment program for the population that we're speaking.
Thank you. I'd like to recognize the presence of Senator Jim Moylan. Thank you for being here, Senator. All right, and so for the Department of Corrections, in Public Law 33-67 mandated the establishment of a hormone or anti-androgen pilot treatment program for persons convicted of a sex crime who are eligible for or sentenced to parole or post-prison supervision. It's commonly known as the chemical castration. What is the status of this pilot treatment program?
At this time, ma'am, there is no status. It never took off. I know they attempted to do it, but there was no funding, and there was no doctor available on the island that we could assist with it, so it never took off.
Is there a doctor available now with for that type of, what kind of doctor what is it that you need?
In May of last year, a memo was sent to the former director advising him that there was no specialized clinic or medical professionals to administer the drug. Currently at the time, there was no physician. At this time to date, we have to reconfirm that.
Who was that letter from?
This was from, there was a committee that put together a DOC that came up and they had the findings. I believe also the chairwoman was also a part of the committee, and those were the findings at the time.
Okay, if you could update us after the hearing,
Absolutely.
What type of doctor, what was it about the doctor that's not available, or is it just they all refused, or is it a certain special kind of doctor that we don't have here? I'm not sure. Okay,
Yes,
appreciate
ma'am.
that. Do you know, Mr. Kanata, the answer to that?
My understanding, they couldn't find one that was willing to administer the program.
Okay, that's important to know, yes. All right. Yes, doctor?
Yeah, I'll go ahead and comment on that because I just kind of looked, I'm not a specialist in this area.
Please.
I just looked up some of the literature regarding chemical castration, and the literature is mixed. just probably you don't want to just jump into literature without having a good thorough vetting. The critics say that, I mean, the therapy is based on hormonal causes. Okay, so you lower the amount of testosterone with a drug, probably given by an endocrinologist, someone who takes care of diabetes. I think there is an endocrinologist here, maybe 2 or 3. They probably won't agree to it because the literature is mixed. The critics say that if you base behavior on a hormone, you're going to have big problems because there's so much more to do with criminal sexual behavior than just the hormone.
All right.
So that the reduction of testosterone isn't the only thing.
Dr. Rapadas, can you state for the record your role are you at the court? Yeah.
Yes, I'm the clinical psychologist at Client Services and Counseling Division. So basically, whenever I am ordered by the judges to do evaluations, I will do them gladly. And and I do some assessments for actually any judge who orders me to do it, I'll do it.
Would those be done, or do you do those pre-sentence?
I think largely it's a mix. I think primarily I do forensic evaluation, so obviously it's before any adjudication or sentencing whatsoever. It's basically a public defender or the judge or the AG wants to know what's going on inside the mind of these offenders.
Do you ever do psychological evaluations for people who are in prison?
No.
What about behavioral health? Do you have that service available?
No.
Thank you.
I believe there is a licensed clinical psychologist in DOC.
Yes.
Yeah, I don't know. I wouldn't know if she does any of those things.
Well, please speak to that.
If I may, yes, Dr. Camilo, she performs the psych evals. However, she's currently off island this time, otherwise she would be present to respond to your questions, ma'am.
So normally, there's somebody on staff to conduct these types of evaluations, and if they're not done, it's because of workload or some other reason?
I can only speak to current, that Dr. Camilo is on board currently, and I believe it's almost been a year, but prior to that, I know we had other possible doctors, but I don't know if they were all full-time. Maybe Mark can elaborate further.
Please.
Prior to Dr. Timelo, there was Dr. Lighthizer. She was also full-time. Prior to Dr. Lighthizer was Dr. George Kalingo. He was part-time. But in my comment about the workload, a lot of it just has to do with the crisis happening. DOC's population has ballooned in the last several years, and so one psychologist for over 600 to 800 clients is a lot of work just to do a psych eval for parole. They do submit the request because I see it. It's just whether it's completed or not. That's another story. But also, the psych eval is quite lengthy.
So we're going to move to the court now because I know they have a report as to their findings on sentencing, rehabilitation programs, and recommendations as to ways to assess risk of repeat criminal sexual conduct offenders. And I'm going to ask for the input also of behavioral health and DOC as to their ability to assess risk. And I know I had asked, how often have judges ordered the maximum sentence in criminal sexual conduct cases before and after 1996? How often have the courts found special circumstances warranted a departure below the minimum in criminal sexual conduct cases? How often have the courts allowed for the option of parole prior to serving the full sentence? And have judges allowed the possibility of parole before sex offenders have served a minimum of 85% of their sentences? If possible, please provide a copy of the annual report submitted to the Judicial Council regarding departures from the mandatory minimum. one of the statutes requires that if they were going to depart and go below the mandatory minimum, they were going to submit reports as to that. So please proceed.
We'll begin by talking about the number of cases that have been filed with the Superior Court of Guam, and then we'll go into some of the recommended education rehabilitation programs. The specific numbers that you requested, Madam Chair, we're still working on those, and then we can get back to you. But we'll have the Clerk of Court of the Superior Court talk about the filings within the Superior Court of Guam, both the felony and the misdemeanor cases.
Thank you, Chief, and thank you, Senators. The data, I guess, to put everybody into context with what type of number of cases that we deal with annually with respect to cases involving criminal sexual conduct crimes under the statute, under Guam law. So what I have provided to the Senator, and I can provide an electronic copy of this data after this roundtable meeting, is data from 2016 to 2019 of criminal cases that are filed annually, and specifically criminal cases involving the crime of criminal sexual conduct. So I will share that from 2016, when the law changed with regard to the mandatory minimum sentencing for CSC cases, the Superior Court of Guam saw a number of 1,682 criminal cases overall that were filed with the court, and of that number, 60 of those cases involved criminal sexual conduct. In 2017, we had 1,497 criminal felony and misdemeanor cases filed, and of that number, 67 of those cases involved criminal sexual conduct offenses. And then in 2018, we saw a spike of the 1,415 criminal felony and misdemeanor cases that were filed. 99 of those cases involved criminal sexual conduct offenses. To date, in 2019, we have a total of 447 criminal felony and misdemeanor case filings, and 20 of those cases involved criminal sexual conduct offenses. So as you can see, based on the total overall criminal cases filed annually, in 2016, the CSC cases make up 3.6% of our criminal case filings. In 2017, they were 4.5% of our criminal case filings. In 2018, they were 7%, and in 2019, currently, they're at 4.5%. I also provided additional data as we annually publish in our annual report on top offenses charged overall, top felony offenses charged, and top misdemeanor offenses charged. But the data that I provided with you today is specific to criminal sexual conduct offenses for 2018. Based on the data that we have, on total offenses charged for 2018, we had 357 offenses involving a variation of criminal sexual conduct offenses under the law. To give you an example, those offenses include second-degree criminal sexual conduct, first-degree, third-degree, fourth-degree CSC, assault with intent to commit CSC, attempted first-degree CSC, and attempted second-degree CSC. For just criminal felony offenses filed related to CSC for 2018, there were 290 of those offenses that involved any CSC offense. And then for misdemeanors for 2018, there were 67 offenses. Now, the numbers vary based on and I'll put it into context. As an example, in 2018, when we had 79 criminal felony cases that were filed, we had 290 offenses. So in those 79 cases, one defendant could have multiple sex offenses charged by the Attorney General's office. So it could be a variety of factors. Maybe there's more than one victim. Maybe there was more than one incident. Maybe there were different dates. And so that's why those numbers vary. So I will share that these numbers are cases that are filed as of record with the Superior Court, and the data does not tell you of those number of cases that were filed, so say of the 99 criminal cases that were filed in 2018, how many of those resulted in convictions, how many of those resulted in dismissals, and any other disposition.
So as we go over and present these numbers to you, again, we'll get back with the other requests that were being made to the judiciary. Our next focus will be on talking about what we are doing in the judiciary. Over the last 3 years, we've implemented change, and that's basically to look at evidence-based practices and see what works. And that's the ability to use the data to help us determine how we're going to proceed, especially within our probation division with the high caseload. One of the key factors is the implementation of the risk, need, and responsivity tool. We identify the risks, we identify the criminogenic needs, and then we develop the proper response to those needs. And so we have a variety of assessment tools that we use within the judiciary, specifically within our probation office and our client services. Within our juveniles, we use the SAVERY, which is a risk assessment tool. And with our adults, we use the Ohio Risk Assessment System, the ORAS. The reason why we selected the ORAS, it goes, in my terms, cradle to grave. So we have a pretrial component, we have a supervision component, we have a reentry component, and we have all these different subsets or subtools within the ORAS that we can use throughout the time that we have with our clients. So one of the things that we're trying to implement, and we've started this over the last 2 years, is the implementation of these risk assessment tools. And then we're looking at what is needed as far as identifying and correcting the criminogenic needs. So as Mark Paris had spoke about, in 2017, what we did was we identified through one of our sub-grants the ability to do cognitive behavior intervention, CBI. CBI for sex offenders, which is what Mark and another one of the staffers were able to participate with, as well as our client services and some of our probation officers. So the cognitive behavior intervention therapy is to assist the clients and assist the inmates with making those changes, making those decisions ahead of time before something worse happens. So that's just cognitive behavior intervention. Taking it from there, the key is the treatment component. And one of the things I'll do is I'll pass it on to Dr. Rapadas, who will talk about some of the treatment things that we have discussed.
Thanks, John. I kind of prepared some notes, just a couple pages. I want to just talk specifically about what we do in terms of the court. So the judiciary's involvement in assessment and treatment, now specifically for sex offenders, is at best minimal. Of course, sex offending is not the only, obviously not, it's not even the highest amount of crimes that happen on Guam, but we are involved in assessment and treatment. And client services, where I work, is the oft-ordered place for assessment and treatment for sex offenders. So for CSC offenders, post-adjudication, and even after a sentence is served, in my experience at the court for the past 4 years, client services is requested to do an assessment for counseling, and they are to follow all treatment recommendations according to their plea agreement. Okay, so in the plea agreement, there's specifically one section that says, for a lot of these folks, after the plea agreement says, go to client services, get an assessment, and follow all treatment recommendations. But also, specifically for sex offenders, there's actually a second section that says, and the person must successfully complete a sex offender counseling, where it's available. So that's written in the order. And then in my mind, I'm thinking, sex offender counseling, what does that mean? Right? And who does that? So in the last couple years, because of the CBISO training, we do have one counselor, actually a couple counselors were trained in CBISO and client services, and we do have one specifically whom I refer to if I feel the person needs a little bit more assessment, possible treatment. My colleague, Ms. Chargaloff, is usually given that case. Okay? Now, the numbers really they're really not that big. I can probably say a dozen in the last year or two that come through this system. And one of our issues when we're kind of deciding and talking about this issue was like, should the client services have some post-adjudicated treatment aspect, because it's kind of a conflict anyway, if you think about it, the court doing treatment, where when there are people who are trained in Guam behavioral too as well. I think there were two that were trained in CBISO, and I believe, and of course DOC. So, I mean, to me, it's okay to have the small numbers, but it's almost like we probably need to get out of the business of doing that specific treatment anyway. You want to? Okay. All right. So, and more often than not, there is no hearing scheduled. So almost the court, I mean, after I do an assessment, there's no hearing scheduled to follow up after I do the assessment.
And that's because once a defendant has been sentenced to serve a sentence at Department of Corrections, the court does not have jurisdiction.
That's right. Okay. And what John was talking about, the Courts Reform Act, which is super great, is the R&R, the Risk Needs Responsivity. So in a lot of ways, the court and all the other partners have done a better job in kind of figuring out, using instruments, what is the risk for these folks, not just for sex offenders, but for everybody, including family violence and drug offenders. Okay? Can I just make some general comments about sex offending, and then maybe another 2 minutes? It's up to you, if you have other questions.
Okay, briefly, yeah.
Yes, all right. So recidivism rates for sex offending is generally pretty low, and it doesn't help, of course it doesn't help victims, especially the ones who've been victimized by sex offenders, but in the whole justice system, recidivism is basically low. In a study published recently in the Journal of Forensic Psychiatry, a researcher followed 406 convicted sex offenders who offended with children. 5 years after discharge, 2.9 recidivated. Those who were treated, okay? So that's very low if you think about it. So those who are treated for sex offending, 2.9, and those who were not treated, 7.4 offended. Okay, go ahead. Did you have a question?
Are those statistics are not from your court system?
And the reason why it's not is because we don't everyone keeps wondering if we have a treatment system. And I don't think we have a good research treatment system. And if it comes down to the bottom line, and if the end of the story really is, we need a system, and that takes money and professionals and things like that.
But do we have those numbers for our system? The recidivism rates for criminal sexual conduct cases on Guam?
I mean, we are starting to capture convictions, dismissals, and any related cases, such that if there were a repeat offender, we do capture that in our system. It's just in the interest of time, we weren't able to get that type of information available to you, but we are working on providing that data.
If you could please, because one of the premises of at least my involvement here is that to us lay people, it does look like the recidivism is high for criminal sexual conduct cases, because we hear often that these are repeat offenders, the ones we're hearing about in the news. So please, if you could clarify that data for us, that's very important to know. And I understand, so Dr. Apadas, you're saying Mr. Lozama, the ORA system, is that specifically for criminal sexual conduct cases, or for all, you're assessing all your crimes with that?
That's for all crimes.
And the CBISO, is that the same as the CBI that you referred to?
That's correct. The CBISO, which is the Cognitive Behavioral Intervention for Sex Offenders, we brought in the trainer, and we provided slots to the Department of Corrections, to Guam Behavioral Health, and to our staff internally for all of our participants to receive that training.
All right.
So CBISO is available. There are a couple of trained individuals at both DOC, Guam Behavioral, and as well as at the judiciary.
All right. I'm hesitating to get into those, I guess, studies that if we can't get the data from Guam, I want to make sure we can get that data. Although I did want to bring up, there are things we can't complete today, right? And so I'm hoping that you can discuss with your agencies some of these items and maybe send to us your recommendations on these things, right? So for example, Senator Shelton sent a letter, and if I may just read one paragraph of it, it talks about one study also, right? And in this study, it says, it found that parole decisions based on institutional behavior and personal disposition and similar metrics had virtually no correlation to post-release outcomes. Other studies point to a certain subgroup of sexual offenders with high rates of recidivism, a group that scored high on psychological metrics of sexual deviancy. So do you believe that your assessment tools are able to capture those distinctions?
The Ohio risk assessment tool is really general. If you're looking at specific to sex offenders, there are risk assessment tools specifically for those cases. What comes to mind to me would be like the Static 99, the Q 2007, and Stable. The acronyms I just pointed out, I need to get back to you on what all three of those actually do. But those are specifically designed assessment tools for clients that have, or individuals charged for those offenses. So we have the Ohio risk assessment that will help the general, I would say the general population at the Department of Corrections, because there is a reentry component to that, there is a supervision component to that, and then specific to sex offenders, then you have other instruments and other tools that are available that require the personnel to administer those tools, to receive the training, validation that they're doing it correctly, and make that available. Then those results from those assessments would then be referred to a professional, a psychologist, psychiatrist, who would then develop the treatment component for the individual based on the risks and based on the results of that. What is also key is constant assessment throughout the process. You can't just assess them in the initial and then say, okay, 10 years later, they're good. There needs to be constant assessment because behavior may change while at the Department of Corrections, just like if they were on probation, behavior can change in the first year versus their third year on probation. So constant assessments, developing the right case plan, developing the right treatment component, and ensuring that they complete that. That's what's going to help us here.
Are these tools then available to judges at sentencing?
I think when the probation officers prepare their pre-sentence investigation reports on the defendant, probation uses the community supervision tool as part of the recommendations that they make to the judge when sentencing.
Because it does show from what our statute shows is supposed to be available as not necessarily available. That's, I think we can all agree on that today, that first of all, they're not able to compare the pre-sentencing reports to the investigation reports that are before them. And they're not able to determine or confirm, or they don't have any assessment tool that the parole board's using other than the investigative report that's being submitted by corrections, right? And in completing that report, it doesn't sound like this ORS tool is currently being used by the parole or by DOC. Is that correct?
Right now is being used for the reentry program and those going into the RSAT program.
Yeah, so the reentry program, my recollection is that that's for non-violent offenders, for sure.
Generally.
Right, they're not eligible. I mean, violent offenders were not eligible
There's
for
a
that.
listing that's
Okay, and so then, we have only recently a rehabilitation program, and so we have yet to see data, I would think, on the recidivism rates after that program.
correct.
All right. But you've got national data that probably led you to adopt the CBI. right?
Yes.
And so could you just tell the panel whether, do you believe that to be the program that we should stick with at this point, or have you inherited that, or do you believe that we should look at something else, or are you currently looking at another type of rehabilitation program?
I think we work hand in hand with the judiciary, and they've been very kind to offer us training when they have received any training. They've invited us to attend. And one of the things I think is that we're all on the same page when it comes to training regarding the ORAS. They brought in the ORAS. We've also trained our parole officers and our caseworkers on ORAS, so they're utilizing that. There's just the different components of it, as the AOC mentioned. So at this point, staying on the same page is probably the best. But at the same time, perhaps then we really need to look into something to expand it strictly for sexual offenders.
All right. Is there a value to distinguishing also between sexual offenders and sexual offenders against minors? Have you seen this in your analysis of the different assessment programs?
Just to comment on that study that you mentioned, I came across the same concept. Basically, it's this, and I think all the researchers in sex offending, especially for children, are pretty much in agreement. So I believe muffness probably might fall into this category of the highest risk, because sex offenders who offend children under age 11 is historically one of the hardest folks to treat and change. Okay, so just think of 11 years old and below. Think of the victim. And I believe that they're called. There's even a name for that type of pedophile. I think it's like hebephrenic, or anyway. It's those who are attracted to pubertal and pre-pubertal victims. There's a bigger chance to push them and nudge them into obviously more appropriate relationships down the line, after they serve their time. It's the ones who focus on 11 and below are the hardest and the most difficult to change. And for me, I mean, the end of the story is, again, the treatment does work. And we always talk about how difficult it is to treat a sex offender. I think if we do the right assessment and we categorize folks in the right dangerousness or anything like that, and whatever instruments we use, we can do a good job, because treatment versus non-treated, it works. If we have no treatment at all, then we're just swimming in the same boat. Treatment for sex offenders does work, and there will be people who resist, most likely those who are attracted to the 11 and younger. And that we could do a good job if we focus on assessment and
Right.
don't generalize on everybody. We just focus on assessment.
Yes.
Right.
Focused assessment, in particular on criminal sexual conduct and criminal sexual conduct against minors, and if that's relevant. And so we want to have confidence in, I guess, the assessment tools that you've chosen. They're being shared across the board. If we could also get the Guam Behavioral Health to also weigh in on that, and pretty much send to us your assessment kind of at this point in time. We believe or do not believe that we should continue using this assessment as to the risk for criminal sexual conduct offenders, and then in particular those against minors. And if you have another recommendation, then please submit that. That's what I want to try to. Yes.
Thank you, Madam Chair. I just wanted to clarify. You mentioned ORAS, Mr. Lozama. Also, CBISO is mentioned. So I just want to be very, very clear. Which risk assessment tool, if any, is provided to the parole board for their judgment? I mean, are any of these risk assessment tools part of the parole file?
No.
I'm not sure if the parole officers have access to the assessment. This is actually a new assessment tool that we've just implemented realistically in the last 18 months. So between Mark and the staff at the Department of Corrections undergoing the training and being able to establish the treatment, the CBISO, after that we can look at it, but I don't believe it's written that it's a mandatory requirement in the parole investigation report?
I think we've established today, according to testimony from the parole board and the Department of Corrections, that that is not.
Right.
There is no assessment in front of the parole board except for the parole report that's provided by DOC. Sometimes attached to that will be a mental evaluation or physical evaluation. Although our statute requires other types of data be provided, those are not provided.
And so we are starting. And so this, as we improve on the risk assessments and we validate the risk assessments, as we develop the treatment component and the CBI training and the CBI courses that are required for the inmates at the Department of Corrections, then the Parole Services Division can certainly look and make those results of those assessments available to the parole board in their determining whether or not to release or remand.
All right, but our goal here is, okay, so to get on the same page, so first of all, that we all determine whether there was rehab available at all. Now we know what type is available recently. We know what is put in front of the parole board when they're making the decisions and what's not. And of course, we want to change that or make it either comply with the statute or change our statute according to these studies to comply with what is better to look at as a factor to determine recidivism or additional crimes against minors. We want to know whether Guam Behavioral Health concurs with this use of this assessment tool or this rehab program, or if there is a better one that you think we should, shift to at this point, because time is of the essence, I think. We've got, as the Department of Corrections has told us, we've got inmates who are ready to be released, especially those based on the old sentencing guidelines, and they're ready to be released, just like the example that we have in front of us. They've finished their prison terms, they've even finished their parole terms, and now they're ready to be released. The only tool we really have available to us is to put them on the sex offender registry. But when I looked at that, the monitoring under that does not seem to, it leaves a lot to be desired. It's pretty much self-monitoring. I mean, they come and report. And so I want to come back to that. But so assessment, treatment, we need to agree whether this is the assessment tool that it is very good. If you recommend in particular that this is an assessment tool that should be put in front of the parole board for criminal sexual conduct offenders in particular. All right.
And Senator, if I may add to that list, I think it's also important because we have both prosecution and defense counsel here, is that they are aware and they understand the risk assessment tools and the assessments that are being done because they make the deals with the defendants. And oftentimes, once the plea agreement's filed and the defendant takes the plea, the judge sentences the defendant. And as Dr. Rapadas alluded to, he said, the order says, and may attend sex offender counseling. Well, what is sex offender counseling? They draft the legal language. They put it in the judgment of conviction that the judge signs and orders the defendant to serve. But we also need to be mindful of the language that's in the legal document that the defendant has to follow, that parole has to follow, that probation has to follow, and that the defendant must follow.
Thank you. That's exactly my next point that I want to just, we're trying to summarize before the senators are going to also ask questions, is that, yes, so ultimately we want to know whether we should restrict sentencing more or plea agreements to, if we are not going to have rehabilitation, or if the rehabilitation is not effective, then should we be allowing these short prison sentences, plea agreements, to shorten them, things like that. Of course, those are the parameters. Is that a report going to be available, the one where they've deviated from the minimum sentence? Okay, that's not available right now. All right, and then, so because the biggest concern is those who are going to be coming out soon, right? And I'm hoping that we, on the legislative side, we can, if necessary, come up with something proactive. If there's no monitoring in place for this, if that's possible, I'd like your recommendations as to what you have seen or recommend as to monitoring of those who are released and on that sex offender registry. we're trying to stop the repeat offense, right?
Senator, may I just make one more comment?
Yes.
Just about assessment, and this is something to keep in mind for the legislature as you're thinking about legislation. Currently on Guam, to assess a sex offender's dangerousness or recidivism, or, the ORAS is basically actuarial. So in effect, you're just looking at the history of the crimes and things like that. So it only hits a certain part for risk of reoffending and recidivism. If you're going to assess a sex offender, on Guam, we only have the first level. What does that mean? What Mr. Lozano was talking about, the static 99 and the other basic risk assessment instruments you can use for sex offenders. And basically, you're just asking them the question. Are you still attracted to so-and-so? And what are you relying on? Their self-report. In interviews or static 99s, a lot of them are just clinical interviews, and you're relying on them. Do you understand that you need to change? Yes, et cetera, et cetera. That's only the first level. Most places in the country have second and third level, and we need to think about funding agencies to start being able to do the second and third level. The second level has to do with biometric, non-invasive things like heart rate, polygraph, blood pressure. You basically attach them, everyone who is assessed who needing this, and just show videos and pictures of certain stimuli, okay? And then the third level is obviously more intrusive, which is what you hear about a lot, with attachment to the sexual organs, things like that. If we're able to get to a second and third level, we'll do a better assessment. I was trained on that. That's all I want to do is assessment and treat in general as a psychologist. I think the mistake that we make is throw everyone in a big net, and we're just wasting resources. We need to focus on who needs it and help them. So it may not even be that we have to spend a lot of money, because there might be only 4 that identified as hebephrenic, for example, as a real pedophile. Or maybe we have 100 pedophiles. We just need to know, and that's only through assessment. Not the first level, though, because that's not effective, and we know that already.
All right, then if you're saying that, then that's exactly what we wanted to know, whether this assessment is effective or not at identifying for all of us who those very high-risk repeat offenders are, particularly those who might offend against minors, right? That's what we want to know. So thank you for your recommendation, and I'm asking all of you to please go back and send to us your best recommendation. I will compile that for the senators, and that's what we want on the table. And I'd like to ask the public defender, Richard Dirks, please.
I'm sorry, you could see I was crawling out of my skin there. Thank you. Years ago, I know it was when there was the federal statute first came in place requiring that every jurisdiction establish a sex offender registry. We had a task force. I think it was a governor's task force. What stuck with me was that at the time we were trying to focus on what do we do with sex offenders, and Dr. Kiffer, who was at that time in charge of client services, had just come back from a training. And he was advocating for certain types of sex offenders. It's a mistake to lump them all together. But he was talking primarily pedophiles and the violent pedophiles. Rather than sending them to prison for a long time and letting them out on the same parole that a burglar or drug user gets out on. And apparently many jurisdictions have done this. You require either a civil commitment to a mental health facility, which I don't think we can do here because we can't do it for our regular mental patients, or extended probation. And I mean 10, 15 years after they get out. The advantage for Guam is that first of all, parole must be overwhelmed. They must be. I don't know how parole can do all the work. They don't have the eyes and ears in the community. They don't have the ability to bring people in for small things. You can put a hold on somebody, you can throw them in jail, but you can't micromanage their lives, which is what pedophiles need. If they were still on probation to the court, there would be a judge in charge. As the court clerk pointed out, when we sentence an offender to prison, the judge loses all jurisdiction. He can't do anything. So if the sentencing will include recommendations that parole make him do something, well, they can't make him do something if they don't have the facilities or the assets. If it goes to probation and some money goes to probation and client services, then we've got something. Dr. Kiffer's training included what Dr. Rapadas was talking about. Have someone trained in the use of a polygraph. And part of the monitoring is bring the man in, he sits down on the polygraph, and you talk to him about what he's been thinking about, and what he's been doing for the last week. And that can be reported to the court. The court can hold periodic hearings to monitor people and see if they're in compliance. The court and client services and probation, if funded, could monitor this much more effectively than we're doing now. So we can change plea agreements, we can put all sorts of stuff in there, but we're sending them all to parole, and parole can't do it all. They just can't. And adding more to the sentences before they get released on parole isn't going to help, because people don't get fixed by being locked up. And it's important, I think Dr. Rapadas pointed this out too, it's important not to lump all these people in together. Our community's been torn apart by a recent notorious case, and I'm trying to think, but over the last 30 years, maybe I've seen a dozen like that. They need to be monitored very closely, and of course it's horrible when something like this happens. But there are much more common fact patterns. Much more criminal sexual conduct occurs because a guy at a dance club grabs a woman. A tremendous amount occurs within the family violence situation. A fact pattern Basil and I have seen a number of times is two domestic partners have a rather bad argument, things settle down, a sexual act occurs, the woman says, he forced me, I was terrified, I wouldn't speak up, I hate him now, I'm terrified, and the man tells the detective, we had makeup sex. They can't be treated the same. I mean, there's an offense there. And a lot of sexual misconduct comes out as violence against women. But it has to be treated differently from the way we treat pedophiles. And the pedophiles need to be watched and monitored in a way that, with all due respect to parole, they can't possibly do it. They can't. We can give them tools and stuff, but I'm sure not even Dr. Rapadas would say that he can predict who's going to reoffend. We need to watch them and test them and monitor them for a long time.
Thank you, Mr. Dirks. That's the premise, is that if we are unable to monitor effectively or unable to assess effectively at various stages, then why are we pushing that decision off? Are you recommending that we not have parole and that all cases remain in the court system? Is that even possible?
Not all cases.
Well, no, your specific, yes, ones where the high risks maybe can be found.
I think it's something we should look at, just because, I probably shouldn't say this, but most criminals who've been through the system for a while prefer to be on parole than to be on probation. Because if you're on parole, don't get arrested, be cool, follow the basic rules, stay out of trouble. But if you're on probation for something, you've really got to do the counseling. You've really, and I don't want to minimize the great work that parole does, but in part, it's just the sheer number of cases. Probation and the court have far more people available than parole does. Probation and the court work with the police department, with the marshals, and they supervise folks. Now, I have great hopes for DOC because we have a former probation officer up there, but I think that I know for people, clients of my own, who are in a family violence situation and going back to the same partner, I push them to go to probation instead because they've got work to do, and locking them up isn't enough. And maybe we need to think about that for certain types of criminal sexual conduct. Just adding years to the sentence isn't going, unless we're going to lock everybody up for life and treat them all the same, it's not going to solve the problem of what we do when they come back to our community. And I'd rather see a much larger component involving psychiatrists and trained counselors and a polygraph if we can afford to buy one. Thank you.
If I could, Senator,
Yes, please.
while I agree with some of what Mr. Dirks has said, just to give you my perspective of this, first off, from within, going back to how long do we keep someone locked up at the Department of Corrections, currently like they indicated, there's just Dr. Taimulu up there. It's impossible to have realistic rehabilitation of anything. There's just not enough professionals in there to provide that. Now, going back to the problem, historically we fudged jurisdictional lines, and we recognize, we're supposed to have 3 branches of government, and that's what Ms. Rossetti was talking about. Once a person is sentenced, the court loses jurisdiction. There have been times where we have worked with defense counsel and we've recommended probation, although normally the person would be eligible for parole once they've completed their term of imprisonment. But we get creative with our documents just to make sure we get the help to the individual as much as we can. But to really emphasize this point, and I think it's very important, I'll ask probation and then parole, manpower. How many probation officers do you have?
We have 60 probation officers that handle juvenile probation, adult pretrial services, adult probation office. They also handle all of our therapeutic courts, our juvenile drug court, our adult drug court, our mental health court, our adult reentry court, and our veterans treatment court and our mental health court. So they're spread out throughout the entire probation division. Their caseload, 7,000. And I know that's one thing that we talked about was managing the caseload with the right amount of probation officers to do the job.
And then the next question is to Mr. Kanata, how many parole officers do you have? Or Ms. Brennan?
We currently have 5. However, one is deployed, so we only have 4, including the chief parole officer.
Yeah. That's where I agree with Mr. Dirks.
That's right. That's what we're trying to show here, is that if we all know the system, and if we all know that, then how are we ending up with sentences that say pass it off to parole or pass it, make a determination at 10, 20 years later without any assessments available, without any rehab available? Those are the huge gaps that we are having. All right, is there anyone in the panel who would like to say something before? Well, let me open it to the senators. They'll ask you some more questions, and then I'll give you one more opportunity after. Okay, Senator Lee.
Thank you, Madam Chair. So we spoke a little bit about cognitive behavioral intervention for sex offenders. We talked about ORAS. And so I'm just trying to wrap my mind around this. And yeah, it might not be popular, but what are your thoughts about just preventing parole for repeat sex offenders, especially against minors, until we adopt this tool, until we can come together as a community, figure out, especially at least the secondary level that Dr. Rapadas was talking about in terms of biometrics and polygraph, if we're able to adopt those assessment tools, figure out what the funding is behind that and how we can get that moving. I mean, what are your thoughts? And I guess I just want to hear from maybe behavioral health, the DOC, and our court system, the AG.
Well, could I just say something here?
Sure.
Okay, so we've been talking about parole, but by the time parole gets an individual, it's at the tail end of their sentence. So obviously we need something much sooner to get treatment.
But it's my understanding that that risk assessment tool is used throughout the course
That's correct.
of... Okay.
And the courts do have the authority to conduct a psychiatric evaluation of all individuals sentenced. It's just rarely used. And as a defense attorney, it's rarely used because, of course, the concern is if they say our client's a pedophile, they'll just lock him up for the rest of his natural life. Okay, but realistically, recidivism is very low for this type of offense. I can't wait till we develop the stats for it. I've been a defense attorney for over 20 years, and I can tell you that they're just not repeat offenders. Most of the people committing sex offenses, maybe Mr. O'Malley can confirm this, are people due to alcohol or drug problems. So once you take care of that, they're not likely to reoffend. And I think that the numbers will show that recidivism is very low. But for those who are diagnosed pedophiles, recidivism is very high, but not everyone who commits a sex offense is a pedophile. And so in the federal system, they have a sexually dangerous person definition. And so if you're diagnosed as a sexually dangerous person, you go to you're civilly committed. You go to North Carolina, and the entire country, that's where they're all housed and treated together. In the entire United States, there are only around 81 people who have been deemed as sexually dangerous. And so, Guam could adopt a similar statute where any sex offenders are required to go through a psychiatric evaluation, and if they're deemed to be sexually dangerous, as in, having pedophilia, then they can start getting treatment. And upon release, because everyone deserves a second chance, unfortunately, but we don't want recidivists, right? Sexual offenses, then we can just have them civilly committed, and through that civil commitment, they can get the treatment and serve sanctions if they're unable to, of course, not repeat. But really, the number of repeat offenders, I would love to see the stats, but I'm pretty sure they're they're extremely low. They probably mirror the national level, I would think, but we just don't have the means to accurately keep those statistics.
Thank you, Mr. Torrey. I know that maybe this is a question that the courts can answer. So did the psychiatric evaluation that the courts perform, or either the courts or maybe the parole office, do you use the sex offender treatment intervention and progress scale, SOTIPS? It's a statistically driven dynamic measure that's designed to aid clinicians, corrections, probation, parole. It focuses on the increasing risk and the treatment of these sex offenders.
It's probably one of probably a half a dozen real good instruments to use that have been researched and validated. But we're not even at that point where a psychological or psychiatric evaluation of these folks are even being done. So, and just in terms of my being a resource, I've forensics and all other kinds of psych evals they're right to just piling up. And to add this is fine. What Steve was talking about, there really is rarity. Who knows? I think if we just get the amount of resources and the type of tools, we can do a better job.
Thank you, Madam Chair.
Thank you. Senator Shelton?
Madam Chair. So I wanted to know from the parole board, I know, Mark, you mentioned that at times the parole board does ask for a psych evaluation, right? So I wanted to know if it is the current practice of the parole board to ask for a psych evaluation for every sexual offender that comes before the board.
Thank you, ma'am. It has been, it is standard practice that we ask for all. But what we've done recently since this incident is that if we have instilled our own in-house policy and added that those with violent crimes, which usually is the first with CSC as well, we will require a psych eval, and we will not hear them until one is provided. And I have that stated in my letter to you all.
Okay.
Thank you.
Thank you very much. And then, Mark, you were talking about the CBI therapy and that because it's new, some people are dropping out. Is it because they're completing their sentence, or is it voluntary?
Some completes their sentence, and others voluntary.
Okay. Okay, and then for DOC, before a sexual offender is released, is there any kind of evaluation that is done for them? I'm sure you evaluate every person before they're released, but is there any kind of special evaluation done for sexual offenders? No.
No, ma'am.
Okay, thank you. And then maybe this is a question for the AG or for the parole board, but what kind of notice is giving to survivors or victims when a sexual offender comes before the board, or when they are up for a hearing or something? What kind of notice is given to victims? Because I've heard from several victims over the last couple of months who say they're not notified in a timely manner, maybe a day before. I just want to understand the process.
If I could refer that to Mr. Kanata, he's in charge, the parole officers are in charge of that.
Okay, before the Crime Victims Act in 2004, parole has always been doing that. It's like a standard.
Okay.
But the law did say that the Attorney General needs to get something from the victim in writing. And even if we don't receive that form, we go ahead and try to make contact with the victims.
Okay.
So
Okay.
the onus basically placed on the victim as of now, that they will provide a written document saying that they want to be notified. There's two parts to that. It's either notify, do not bother me. That's one.
Oh, to opt out of being
Yeah,
notified.
yes.
Okay, and how many days in advance will you give a victim notice?
We're supposed to get it once they start, like at least 30 days prior.
30 days.
for them
Okay.
to respond.
And so for the AG, if there is there a victim's notice too, if there's any other type of hearing?
We normally try and notify victims about all hearings. The problem you got to keep in mind with, especially with the parole hearings, especially in this situation, what we're talking about with sex offenders, is usually years after the incident, and then contact information for the individual is dated. But we do make efforts to contact them, and I know our Victim Service Center is in contact with the parole office to provide all the information we have about the victim.
And that's a really easy fix. I mean, parole or casework does a computation sheet. If that computation sheet went to the sex offender registry, the registry could, provide that information on site. And so, like, a lot of victims, of course, keep track of the registry, and they can see, like, he's coming up for parole, and then they'll give them more information as to when this individual will be released. So I'm not sure if there are rules against the computation sheet being provided to the court's sex offender registry, but I mean, it's a fairly detailed registry, so it should be able to include things like parole eligibility date, full-time release date, and things like that. So it shouldn't be that, right? That's an easy thing.
Senator, if I may, though, I want to add, because I did have this discussion with the Attorney General, to clarify in this case and another case who's notifying, and it was very clear from the Attorney General that if they're up for parole, that it was not their office. It was going to be the parole office, and so if they do or they don't, do you have a percentage how often you miss?
No, every hearing that comes before the board, it's always the parole officer's responsibility to make contact. And we work well with the AG's office, the victim unit.
Right, so they're assisting, but they're not responsible.
Okay. So, but for the AG, if it's not dealing with parole, if it's a different type of hearing, what kind of notice do you give, your typical amount of time?
For which kind of hearing?
Anything to do, I don't know, whenever a victim should be notified.
We do our best to make sure our Victim Service Center and our victim notification units keep in contact with our victims, not just for sex crimes, but for all of our victims.
And what is the typical amount of time you give them a notification?
I cannot answer that question. That's in a different section.
If I may, Senator, it's kind of outside the scope of this hearing, but it was in the scope of another oversight hearing with the AG's office several years ago. So that is an issue that has been brought up, and I will give you those statutes so we can follow up on that also. There have been questions, Basil, just so you have a heads up, as to whether they're still on top of that. I know that they had kind of restructured and gotten, very good at it, and so I guess, but people are calling now, so we want to hear about that also.
Yeah, just to make sure that we put the victims' rights at the forefront as well. So it's just Masi, Madam Chair.
Thank you very much, Senator. Senator Marsh?
Suzu Masi, Madam Chair. So I have a few questions here. There was one statement that, according to his understanding, that most of these sex offenders are committing these crimes because they are being influenced by drug or alcohol. Is this other people's findings as well?
That drug and alcohol, that's an excuse they use.
Okay. And this just occurred to me as we were talking about the sex offender registry. I had heard recently of somebody who supposedly, I did not follow up on it, but who has supposedly, in the way that it was written about them signing up for the registry, that they were able to skirt around that. Is that an issue that others have heard of, that there are people who are supposed to be signing up for it, but yet do not?
As far as parolees, people reporting, we remind them and we make sure that they go there. Because if they don't, it becomes a federal offense.
Okay, I will follow up on that one story to see if that was indeed the case. I know that sometimes rumors run around the community and they don't always end up being the case. So to understand this landscape, I was very concerned with the terms of there being low percentages of those who have recidivism and low percentages. So from any reading that I've done over the years, it's just my understanding that for every person caught once or the second or repeat times, do we have any understanding how many are in our community that are not being charged and not being caught? Because when we're saying things like low numbers, I find that concerning, and it doesn't match up with other things that I've read about communities in general. Anybody who can answer it.
Senator Marsh, let me try and take a stab at this. If I understand your question correctly, you're saying nationwide, it appears that for a lot of people, the only numbers we have are people who report a crime, and that there are a lot of people out there who are not reporting. Well, my understanding of the recent stories concerning Guam is our percentages are above the national norm. So I think our reporting of crimes is much higher here than in other places. So I believe, especially with a lot of the education provided with you, the Department of Education, with the good touch, bad touch programs, that it's a very aggressive community we have in reporting offenses.
that is good to hear. I would like to see some statistics, and I will continue to look for them or ask for them about the rate of it being the rate of people being charged or it being reported, and how many are actually out there. The other part of that, with to focus on low numbers, I just want to make sure it's not distorting an understanding of how many victims there are per person caught. You know, we've heard stories over the last few years about one person conducting these sort of acts amongst dozens or more. So do we have any understanding, for whoever can answer, about how many victims there are per person caught?
So like if they're like reoffend, right? Did they only hurt one person, or are there several victims involved? Is there a database for that?
Well, I know that Sophie, Danielle actually provided some stats, like in 2018, there were 99 actual cases involving sexual conduct, but it included somewhere of like, what were the numbers? Like 357 of separate charges were involved in those 99 cases, right? Was that your?
Yes.
So, yeah, there are cases out there with multiple offenders, and there are cases where they were obviously multiple offenses against the same victims.
And it could be where it's one case with multiple offenses on the same victim, or multiple offenses of numerous victims. So the statistics that we had presented just talks about the number of cases that were filed. Within the 99 cases that were filed, there were 260 specific charges that were all encumbered into those 99 cases. So again, it could be one case with 4 charges, one case with 1 charge. And that's the statistics that we provided earlier.
Do you understand which is more common, that this one person being charged having several victims, like multiple victims? Is that more often the case, or is it just is it more often the case that it's against one victim? Do you know?
We don't have the data to determine that at this
Well,
time.
the data we provided clearly shows that in 2018, the second degree CSC obviously ranked one of the top 5 offenses charged, and these were from minors less than 14. Clearly, the prosecutor has the discretion to charge these cases out, so perhaps maybe Basil might know, based on the cases that you file, are there different victims usually, same victim?
Usually, what we see in a lot of these cases, it's there's just multiple counts of but it's the same victim, and that's why the numbers might seem very inflated.
If I may just ask, could you please submit data to us, a report that shows different victims, same offender, multiple offenses, same victim, just so we can get an idea what the reality is? Thank you.
Sijus Masi for that. And so again, not to be focusing just on those terms about recidivism being low, do you think that those numbers are low because they may be reoffending, but those offenses are not being reported? I'd like to believe they're low, but over the years, again, as I've read through things, my understanding is that repeat offenders are high amongst sexual offenders, but maybe some of my reading is outdated at this point.
those are unreported, Senator?
Right. Do you, I just, with the focus on it being that the recidivism is low, I just wonder to what degree that there are continued offenses, but just perhaps not being reported. And so maybe that can't be answered, but I think it's important for us to keep in mind that if we're focusing too much on low recidivism, we may be congratulating ourselves when it's not really there. So I just want to, as Senator Shelton was saying, on behalf of the victims, I just really want to make sure we're looking at this as comprehensively as possible. And so I know it doesn't fit in with the scope of what we're looking at per se, but I think an important part of this conversation also is just continuing to build up those programs that are about empowering our youth and making sure that we have self-defense programs out there so that we're preventing it before we even have to have these conversations about parole and treatment as much as possible.
Senator, I'll just make a quick comment about that. All the literature is pretty consistent. Treatment for sex offenders lowers recidivism drastically. The ones who reoffend are the untreated, and their recidivism is low, but those who are treated is much, much lower. So I think the end of the story, like I said, was treatment is, if we can get that going here, like consistent treatment for those who are assessed as needing treatment, I think that would be probably the best approach.
If we could also get a different report, because the recent annual report shows felonies committed during felon release, right? That's one of the things that the media thankfully picked up on. And I think that's what the senator's talking about. We're being told here that the recidivism is low, but those numbers show us some startling information. So just, yeah, we want to make sure we're not generalizing Guam anymore. We want very specific to Guam. We want to know exactly what our reality is so we can deal exactly with our reality. Senator Torres.
Thank you, Madam Chair. I want to thank all of you for your input today. I mean, clearly this is a very complex and sensitive subject, and I'm glad that we're able to get all the perspectives together so that as policymakers we can also determine what, from a policy perspective, would be helpful in terms of making all your efforts compatible and smooth. And I think my colleague, Senator Marsh Taitano, touched on something that I was thinking about too, that one of the players on the table that we're not hearing from that could give us an idea of the systemic nature of this and the root problem from the base level, that's occurring in our community. When you think about, from a public health perspective, the amount of sexually transmitted diseases that permeate our society, when you look at the high pregnancy rate for teenagers, there clearly is a problem in the community that sexual misbehavior is showing itself. And what I wanted to further talk about though today is, from your perspectives, I mean, everybody has a place in terms of assessment at every tier of dealing with a criminal offender, including when they're eligible for parole. But insofar as the rehabilitation aspect, is that area of responsibility greater borne with the Guam Behavioral and Wellness Center, or is it it's a level of counseling and rehabilitation and treatment, a combination of efforts between counselors at the probation within the Superior Court, or is it counselors within DOC, or is it behavioral health? And how does that play out, and how can we better affect that component of rehabilitation?
Thank you, Senator. Once again, for the record, there is no current treatment or program for sex offenders, and so that's the baseline we're looking at. So I think your question of where is the treatment best suited is the question. It's one of the things that I was going to respond to in my follow-up information that I will provide the committee. And in the research, of course, I totally agree with Guam Behavioral Health that instead of lumping everyone up into an assessment tool, the same assessment tool, we have to be very specific if we want to get to treating and getting the right data for the right offense. So thank you, Dr. Rapadas, for mentioning that we need to ensure that the assessment tools, we're talking today sexual offenders, then we need to ensure that the tools used measure that act. Number one. Number two, where does the treatment lie? Should the treatment be at the court or should it be at Guam Behavioral Health? There is data out there, in speaking to the professionals in my department, specific assessments for sexual offenders exist, so that's a good thing. There are tools out there very specific to sexual offense when it comes to assessments. The question is, who's going to evaluate the best one? But at least we know there are assessment tools for sex offenders. In speaking to our psychologists and our psychiatrists, it looks like in the readings and in the research that we have done that most of these lie in the correctional facility. These programs lie in the correctional facilities. But one thing's for sure is that the psychological evaluations have to, and I think it was repeated several times here, has to be conducted throughout the treatment. So absolutely there is room for a sex offender program at Guam Behavioral Health. But then again, we need to get those specific professionals, specific programs in place for that offense. So today we have none, but this is a good start in ensuring that if we want to make significant impact and move the needle, that we need to start thinking specifically of these severe offenses to our children and to our to the victims, right? So I'm here to state that at Guam Behavioral Health there's room for it, but there's going to be a need to be a lot of investment put into this, and I think that's why we're all here, right? So I hope that clears up any position I might have. The willingness, of course, but there's always some investment that needs to happen in the center. Okay? Thank you.
I guess as a follow-up, I just want to ask the court, though, is within the probation and your counseling services, is there a fit for that as well? The sexual misconduct treatment and rehab, does that happen also at your level, or is it generally those sorts of services just referred out?
For sex offenders, for the last 4 years, for me, when a defendant or a client is adjudicated already and has their plea agreement, that's normally when we see sometimes in the order for an assessment to be done at client services for treatment. And then often for sex offenders, there's that second part that says enter into a sex offender counseling program, but which we can't identify. However, when I assess that there's a lot more to the story, and that maybe that the person does need help, I refer them to Ms. Chargaloff, who was the CBISO trained, similar to in our office, and she's able to do a further assessment and then carry the case as long as she feels deemed appropriate. Yeah.
But to follow up with that, most of the defendants for sex offenses that are typically on probation, because when the law changed, it was a mandatory minimum of 15 years. So once the judge sentences them to serve a sentence at DOC, we're talking about the cases he sees are not the first degree CSC type matters, right? They're probably fourth degree, third degree, not the ones that the law says you have to serve a mandatory minimum sentence of 15 years.
That's right. That's a good point. That anyone who I've seen over the last 3 or 4 years are fourth degree folks who are already in the community but are being monitored. But yeah, not the kinds that folks that we're talking about.
Thank you, Senator. Senator Moylan.
Thank you. Thank you, Madam Chair. I have a good experience with a few people on this board here. I want to say hi to Chief Mike Kanata and my fellow parole officer over there, John Lazamag. We were all parole officers back then. It's about 22 years ago when we had more hair. But now we're on different sides of the table, so hopefully we can all work well together and help out things. But I remember back then, I think we had, Chief, if you recall, maybe 8 parole officers back then, 10 back then, with less parolees than now as well. 50 back then. Oh yeah. And our monitoring system was pretty good back then. We were able to, there's probably not one parolee that I didn't put back in prison for a little bit, so I always got our man. But I wanted to say with Mr. Lizama, he was talking about constant assessment. And that's just like what we were in parole all the time. We were constantly on top of our parolees. But now with the hundreds more of parolees, to include probations, I think people on probation far outnumber the ones on parole. Is that correct? Your probation numbers are how many?
7,000. And then the number of probation officers is around 60.
Yeah, so would you think that was a good suggestion if we stopped the parole officers and just put it on to the probation? Logically, it doesn't sound like that's even possible.
I think it's too early to decide whether or not you would completely abolish parole and move it to probation without having somebody come in and do an assessment of the specific functions and the roles between the probation officer and the parole officers. There's also jurisdictional issues that need to be addressed because the parole officers work for the Department of Corrections. They present to the Territorial Parole Board, whereas the probation officers make their recommendations to our Superior Court judges. So there's jurisdictional issues that need to be looked into, and basically, I know there was a talk about moving it over to probation, but when you move from one to another, is that really the solution? We need to look at it holistically and look at where are the gaps within each or any of the agencies, and let's look at responding to those gaps and meeting the needs of the community. And I think that's what, correct me if I'm wrong, Madam Chair, that's what we're here to do. So for me to say that we should abolish parole and move them to probation, it's too early. I wouldn't even recommend it or consider it without a valid study.
I think with your numbers alone at 7,000.
It's going to be overwhelming.
Yeah, and the problem with that is the treatment won't happen until after the release, and this kind of treatment needs to happen as soon as possible, like once they're sentenced, serving their time. That way they can develop, a course of conduct and a pattern. And really, it takes 3 years to develop like new habits. So it shouldn't really lay with parole. Maybe it should lay with the casework division. I mean, unfortunately, as DOC, right, their budget shrinks, they lose their parole officers and their counselors first, and then they, of course, they're the last ones to get filled. I think they're both understaffed by what, half? You guys are at half, and casework is like at half. And how much do you guys have in your counseling division? How many people are in counseling?
How many social workers?
Or social workers?
One's a supervisor one is a supervisor getting ready to retire.
So, and unfortunately, those are the last positions to get filled because obviously we need guards, to guard our inmates over there.
But, for the record, in our 2020 budget, I did ask for recruitment for parole as well as for casework. I believe it was 1 parole officer and 2 caseworkers to move it forward. Currently, our parole officers supervise 333 parole individuals that are on parole. So it doesn't seem like a big number, but when you're looking at the population as compared to how many officers we have, it is currently a big number. And coming on board, one of the things that we want to move forward with our parole division is to have more community outreach and stuff, which means our parole officers will go out in the field more often. So that's something we're working on. We're going to come up with a plan. We're going to implement that plan, and then they can go out and they can do more field work and monitor our parole population better.
And they do have the reentry program, but the reentry program isn't geared towards these kind of specialized defendants. So maybe at least it's a good model that the legislature could look at. If we can't have court supervise everyone, how about a special program that can supervise those who've been deemed like sexually dangerous individuals? Because they definitely need constant supervision if they're going to be released back into society. And so I actually have a draft one I'll provide to the speakers from the state of Illinois. The Adam Walsh Act is the federal law, and I mentioned that earlier, where, for the entire country, there's only like 81 people, but it's a separate facility where they receive intensive treatment. Maybe our own AG, our U.S. attorney can, have people diagnosed or deemed sexually dangerous and have them sent or civilly committed to the prison in North Carolina.
In addition to monitoring, and since we're overwhelmed with both parole and probation, I think the court was also looking at the ankle bracelets as well at one time.
We're currently in the process of testing all of the electronic monitoring bids that we have going on that we received. By this summer, we will be awarding that contract, and we will have clients or defendants, inmates on electronic monitoring. So that's really just in the pretrial stages, where we are not looking at our post-adjudication probation clients. That's strictly, that was a presentation I made several years ago to the 33rd and the 34th Guam legislature for support of electronic monitoring for the purpose of reducing the detainee population at DOC. So we do have the funding to do that. We're testing the equipment. We're going to launch, like Chief Justice Merriman had said, in the summer. We'll assess it. We are not looking at post-judgment cases, not even within our probation division. So that's where we're at with that.
Yeah, possibly we can take that further. Of course, that will be, it's a deterrent. If you're wearing the ankle thing, hopefully you think twice, because we do have a lot of folks on pretrial that still commit crimes while they're on pretrial.
Yes.
And maybe for parole, we can use that ankle bracelet as well, since they're overwhelmed as well, maybe starting with the CSC as a deterrent.
And certainly, Senator, when we actually launch, I can call Chief Kanata and Director Brennan to observe our program, our electronic monitoring program, and if that's something that the Department of Corrections, the Parole Services Division wants to expand to the parolees, at least they'll be able to see the product that we're utilizing here on Guam.
Okay, I just have one more question regarding that level 2 and 3 for Dr. Ripadas with the polygraph machine. Just from my experience at corrections, I would say that will be really helpful, because truthfully, when I was a parole officer writing all these reports, I'd never met so many innocent people until I talked to an inmate. Everybody is innocent. So if you need to get to second and third degree level, for them to tell the truth by machine, maybe that will be really helpful. Thank you. Thank you, Madam Chair.
Thank you, Senator. Senator Nelson, Vice Speaker.
Thank you, Madam Chair. Excuse me. First of all, I want to thank all of you for coming here today. Really, it's a community effort with all of our agencies because we cannot make any movement if our agencies were not on the same page or if there's a hint of reluctance on moving forward to come to a solution. And maybe perhaps policy could be the best solution. Some of the challenges we are facing is funding. You mentioned the electronic monitoring program, which cost $500,000 up front that we appropriated last term, which should save DOC $2.2 million. So, be on the lookout for that cost savings and ensure that and the appropriation, you keep the $2.2 million that it was intended for your DOC. It's not taken out. But I do have a question for Ms. Taitano. You mentioned, we all discussed that psych evals did not come as part of the parole packet. And so I just want to ensure, if I heard correctly, that before you move forward with perhaps CSC offenders, you are going to wait until you have the psych evaluation on hand.
Yes, ma'am, we just developed that in-house policy.
Okay.
It is actually for violent crimes, but perhaps we can amend that to also include CSCs, because violent could also include CSC and other crimes.
Right, so you're going to implement this in your policy and it'll be standard practice?
Yes,
Okay.
yes. Although it has been standard practice to ask for psych evals currently, but for this, we want to see it more, for sure.
Right. So perhaps historically, some decisions were made without a psych evaluation. Is that correct?
Yes, ma'am.
Thank you. And I'm really curious that Dr. Rapadas brought up the first, secondary, and tertiary testing for extreme cases, right? We focus mostly on the pedophiles, like the previous gentleman back there. I'm sorry I didn't get your name, but Dr. Dirks, right? Is it Oh, you're not a doctor, you're attorney. Okay. Attorney Dirks, okay. Nice to meet you. And so, do we have a cost for this? And perhaps, is there statistically a number that we have traditionally on these pedophile cases that we can anticipate to go through this process?
There is actually a secondary assessment we're talking about. It. There's one on market called ABLE, the ABLE assessment. That's $2,000. I found
per individual?
Well, it's $2,000 for the instrument, and I believe every one that you do, you gotta mail in the protocol, and they'll charge like $50 to $100 per protocol.
Okay. And can this be done within the judiciary level? Can they implement a policy to do this, or do we have to change the statute or include it in the statute to make it a requirement? Can it be a simple decision that the management makes?
The only thing I would say is that, okay, so when I'm ordered to do something by the judges, I'll do it. But historically, like I've been saying, is that a lot of times the folks that do come to me are fourth degree, post-adjudication, not really monitored or supervised, likely would not be needing the secondary and tertiary ones. Obviously, if we manipulate money, we can get it, and it could be used for.
But we are just focusing on the pedophiles, right? The ones that are harming the children. So
and so I would not necessarily see the serious pedophiles in the court.
Judiciary. Oh, okay.
Yeah, go ahead.
Who can address that? Would it be DOC?
I believe it'd be DOC, but at this time, I would defer to Dr. Taimalo when she returns. It's something that I just wrote down that I'm going to ask her to look into, and perhaps that's something we can really find out and the cost of it, and then maybe get permission to implement it. So it's something I definitely will look into.
Thank you, Director. And the continuum of treatment, right? So we have the assessment done at the judiciary part, and then the recommendation is a continuum of care or treatment for those continued sex offenders throughout their time being served at Department of Corrections. What are the resources that we will need for this continuum of treatment? And perhaps could it be like a MOU or MOA between the judiciary to ensure that the documents are made available to both agencies? Or do we need to implement a statute for that?
Are you speaking specifically regarding the pre-sentence investigation report?
Yes, the pre-sentence, but specifically also for the CSC, right? Not you do other risk assessments and so forth, but specifically for CSC offenders.
So I think our probation officers, when they make the recommendations prior to sentencing, use the ORAS tool as one of the factors in making those recommendations. And I believe DOC as well, they use the tool, part of the suite is the reentry tool that Mark alluded to earlier. But I think when there is a recommendation to provide treatment, it's as ordered. I don't think there's anything specific that says, this offender should go through the ABLE, as Dr. Rapadas was alluding to. I don't think the tool was set up generally to target sex offender treatment.
Right, the ORAS does not. So
No.
it's a different kind of assessment. But I'm talking about specifically for CSC. What can we do to guarantee that or make steps forward to perhaps provide a continuum of care or rehabilitation for the individual?
And I think the way we did it at the court when we started our adult reform in the criminal context was we took a look at what are the best practices in other court jurisdictions, what tools are out there, and we studied it with our judges, with our probation officers, with myself. We had a team together, and then we said we were going to use this risk assessment tool. So we did a study on what was the best tool, and that was how we ultimately determined that it was going to be the Ohio Risk Assessment Suite that we use. And then we brought in, of course, our stakeholders like DOC, because there's a component there. So perhaps we've recognized today that there is nothing that we're using now. Maybe that's what we need to do, is come together again and look at what tools are out there that we can adopt.
Yeah, and that's okay, right? It's okay that, this is something that we did not foresee, that, the ORAS is a great tool and it's made a lot of progress for the individuals and also for the support at transitioning into DOC. So, that's okay if we don't have it now. We could not predict what have happened, that this would become such a grave issue. So I also want to discuss the probation versus parole. The probation part that we are looking forward to, or that we are looking perhaps a solution is not to throw every offender of the like into a probationary program. It's to concentrate on the, is the word deviant appropriate to use? It's to concentrate on the deviants to ensure that they receive a continued monitoring program for them. Is this a possible avenue that we can look into, and would the management in these agencies be willing to come into agreement, and perhaps what we would need to do to make this happen, if there is an agreement that it's something that we could look at and possibly implement?
We can certainly look at how it impacts both parole and probation. Statutorily, there are some changes that need to be made if someone is going to be part of it. That's the thing we're doing now with our adult reentry court. So we have a pilot program where we're able to get those that are coming out on parole under the supervision of our probation officers. I believe that once we're able to work out the kinks and see whether or not the adult reentry program is a valid program and it's something that we can continue to the other case types, then we can certainly look at it. It's still early enough within our adult reentry court program to say we can take them all. And I'm certainly not going to say that. You know, we have to look at validating whether or not the adult reentry court program works. And then we can look at how we can model that to other case types that can be supported. And of course, we're going to come to the table here and see about legislation that needs to change the specific statute and laws and procedures so that those individuals coming out of the Department of Corrections, jurisdictionally, they can be supervised by probation officers and not parole officers.
Thank you. So, Chief Lizama, is that a commitment that we will look at this avenue?
We are certainly going to look
you.
at it. And I think one of the things we've done historically with any of our therapeutic courts, we've always come before the legislature to talk about the successes or the challenges that we've had in each of our courts. And we've been able to do this since our inception of our adult drug court and our juvenile drug court back in the 90s. So we'll continue to come to you and say, we need to continue this program. And in order for us to continue this, we're going to move from grant funding to, we're going to need local funding to do it. So as we look at adult reentry, the success, the challenges, we can certainly see how we can expand that to other case types.
Right. I understand that it would require additional funding. Your probation officers have a really big load, so I understand the gravity of that. Thank you. Thank you all for the work that you do. Thank you for your service. Thank you, Madam Chair.
Can I just add, so thank you, AOC, because that would be really great for DOC. But I think he talks about statute and stuff like that. If I'm not an attorney, but I believe if you have an individual that's sentenced and serves time at DOC, they have there any kind of incarceration that they have to go on parole. And that's when we talk about the reentry court, that the judge has to make a decision with the AGs and the defense counsel's agreement that they are going to be placed on probation. Because I believe, if I'm not mistaken, statute is they serve any form of time, they have to go on parole. So that's something in statute that maybe we need to address. That's one thing. The other thing is we talk about these programs that we want to get them to. Dr. Juan talked extensively about that and stuff like that. That's something really great, and that's something I definitely will talk to Dr. Tamago and look forward to it. But I think in any judgment or any plea agreement they come forward from the AGs or defense counsel, that should be incorporated. Sometimes they say you have to go to client services. Sometimes you have to complete treatment at mental health and stuff, or now it might say at DOC in a specific, so that when parole is monitoring them and supervising them, that's something that we got to check off prior to them getting released on their full-time release to parole, or if they get out with the earlier with the parole board. So that's something, again, that we definitely have to look into and look at the plea agreements and judgments.
Excellent point. That brings us full circle to, it kind of begins with sentencing, and we want, of course, our courts to have the best tools available to them, and we want to know if there are gaps in what the courts have available to them. And in particular, we very much, because particularly us here today, are concerned about the potential of sex crimes against our youth, right? We want to prevent that. They look preventable if it's being done by somebody who's done the same type of crime before. That's what our lay interpretation is. And if that's the case with the assessments, then obviously we want you to use those. We want every part of our system to have that available to them, and that we shouldn't have parole, or, all the decisions have to be based on that, on assessment. We need to know if rehabilitation is actually effective, right? So we're trying a new program, and we want to know if this is actually effective. So hopefully, the sooner you can just keep studying that. But what we want is not to delay. We want to know if you find out a better way to rehabilitate, let's get that to DOC, right? If DOC decides this one's not effective, then please let us know how we can help you to change it up. That's why we have behavioral health here. We want the experts in the room, and we want you to know that we want very much to see results, that if we can stop that gap where, for example, he describes them as pedophiles. If pedophiles, known pedophiles, and they should be known, right? Meaning we should do the assessments if those are available to us on Guam, and not not pretend that we don't need to know, not hide that information from the people here at DOC, not hide that information from the people at the parole who are telling the community these people are safe or not to be released. So I want to close that gap where it looked like they were going to know, right? Like the assessments all along the line, and they are able to see progress or if they've made no progress from sentencing. And so hopefully we can get those information that the courts have available to them to be the best information available, and that is also shared with everyone else who's going to have a role in this process. So rehab, is it effective? Assessment, is it specialized enough, effective for this, what we're talking about, and can it be used by the others? We don't want release unless that they have to vouch that it's safe for the community to release these people. We want everybody on the same page when it comes to that. And if we are totally guessing right now, because we have no rehab programs, whether these people are safe or not, then I think we're completely negligent. I mean, that's how I feel. Like, that's why I'm calling this, because I feel like if I'm a policymaker, then we're negligent to allow that. We need to stop that. So let's put all our best tools on this table for all of us to use and just stop those. And we can't solve everything at once, but let's stop those known offenders who are inclined to repeat. Please, let's stop those. So my urgent concern is that we have offenders who are coming up for release. So I've asked Department of Correction to give us a list. Some of these will be on the sex offender registry. Well, I think most of them should be. We're talking about the violent offenders, so they should be listed on the registry. But from the looks of it, to me, there is no monitoring after release. After parole, when they're released, there's no further monitoring except that they report to the sex offender registry, I think once a year. So I want to know your best recommendations as to that. If we know they are, for example, pedophiles, and I'm not using that term lightly, I don't like to use labels, but that type of criminal, if we know that, and we are releasing them, because right now that's the state of our laws, that we are going to release them. They're releasable, okay? So they're going to be released. So I want to know your best recommendation of, can we monitor them? What else can we do? What can we do? Can you assess them before they get out so we know which ones we can monitor or do something else with? Please, your best recommendation on that would be very much appreciated. And that I find kind of urgent, because I'm guessing that this is happening daily, that their release times come up and parole hearings continue to go on. All right. So again, just some of the details that we've asked for, if we could follow up. Recommendations regarding the use of risk assessment, the best type of risk assessment, particularly for repeat offenders against minors. Recommendations for types of treatment, effectiveness, recommendations for monitoring. The list from the DOC is those who are going to be released, and if we know anything about them as to these types of criteria that we've been discussing. The reports from the judges, whether they're deviating from minimum sentences, and if that is something we should look at or not. For example, is it it's supposed to be based on specific criteria, so are they following that? You know, do we need to tighten that up? Do they not have enough information available to them, perhaps, and that's why they're finding something that 20 years later we're finding looks unreasonable? Should we require courts to do psych evaluations to determine if they are pedophiles or sexually dangerous persons? Requiring that. And if, or sharing pre-sentence reports, right? If that information is adequately assessed in there, so that we know upfront at sentencing whether in the end these people, we want them released or we don't, right? Or it's likely that they can be rehabilitated or not. And so that's the goal, and I very much thank all of you for your input here and for being very honest with us and putting those types of things on the table. Yes, Denya.
Senator, just to clarify for the data that we will be providing, I'd ask that we provide data with respect to the courts as early as 2016 forward. Our case management system we capture the data, but I think the cleaner data that we need to audit in the interest of time to get you the information, my position is that we start from 2016 when the law changed with the mandatory minimum moving forward.
Thank you very much. Is there anything anyone would like to add to this discussion? Michelle?
Yes, ma'am, thank you. Number 9 and 10, I would like to share of my submitted report/testimony, is that we mandate that victims receive inmates' periodical reports and progress as they go through incarceration. This is to keep the victims notified of the progress, and then because eventually the inmate, if he has a sentence 10 years, they're going to come out. So the victims need to be prepared at one point or another. And then also, the AGs, thanks to the AGs, maybe some funding can go into the AGs to help with the post-incarceration of the victims' advocates there, so that they can follow up with the victims also. I think that'll help with that, ma'am, to mitigate their fears and concerns. Instead of currently, they just see the offender as they were 20 or 30 years ago. They don't see anything other than what we see, and we're not able to share some of that information. Yeah. So thank you, and please, if you can read my report, I'd appreciate that.
If then the Department of Corrections could also weigh in on whether some type of periodic status report on persons in DLC is appropriate or not. Or she's suggesting that the victims be notified periodically of the status of the offender in prison. And so I want you to weigh in on that, whether that's appropriate. What type of report would that look like? What kind of information, I guess, would be public at that point? Thank you. Anyone else? Thank you again. To my colleagues and to all of you for your time and your attention to this. Please give my regards to the judiciary also. Thank you. Thank you.